3, 2, 1, start. Article 141 direction was to make regular appointment of lecturers on the sectioned post within time frame and till then the ad hoc teachers were permitted to continue. Appointments not made within the time frame, no doubt. The judgment of the apex court must be respected by all concerned, including those who were not parties thereto. However, there is now sea change in view of the decision passed in the Uma Devi case. Even if a violation of court's order in that behalf had taken place, the same by itself would not lead to an inference that the correspondents were still to obey the order. Ad hoc teachers cannot be permitted to continue even if the regular appointments have not been made within the time frame as earlier directed. Article 226 Alternative Remedy Agreement containing arbitration clause writ petition filed without invoking arbitration clause. Single judge did not record any finding on it and allowed writ held not sustainable. Article 226 Judicial Review of Punishment Order Scope of Jurisdictional Sweep of Provisions of Article 226 for Judicial Review of Departmental Actions is circumscribed. Writ jurisdiction is not to be treated as an appellate authority in a writ jurisdiction. Main anxiety should be to consider as to whether decisions making process adopted and undertaken by the authorities is in any way influenced or fettered. If not ordinarily, writ court will not interfere. Full stop. Article 226 Judicial Review The courts pick out the golden thread of reason and meaning in a law, comma, shape and mold the law, reveal its fineness and nuances, smooth the angularities, strike down the bad law or illegal action, and, most essential of all, exert the strong moral forces of restraint in times when expediency is all the doctrine of judicial review is the enforcement of the rights assured and guaranteed under the Constitution through constitutional remedies. The fundamental object is exert a great moral force upon the legislature to keep it within the limits of the Constitution, to save the people from the democratic tyranny. The courts, however, adopt judicial restraint in order to maintain harmony between judiciary and the legislature. Full stop. Article 226 Judicial Review of Legislative Action. There is a presumption in favor of the constitutionality of the statute, and the onus to prove lies on the person who challenges it as unconstitutional. The validity of the legislation is not to be judged merely by affidavits filed by the parties, but all the other relevant circumstances like its history, object, etc. The grounds for striking down an act are mainly lack of legislative competence and violation of fundamental rights or other constitutional or legal provisions. Full stop. Judicial review of an administrative action. Law with regard to the judicial review of an administrative act requires restraint, but where illegality is apparent inasmuch as the decision maker has not correctly understood the law that regulates his decision making power. Order is bad. If the order suffers from irrationality, it is again bad. Full stop.